Hello, this is Matt on the Moon Lambo channel, and here's a headline from Crypto News Flash. Response on February 15th, question mark? FOIA request from Ripple could be pivotal, says lawyer. Now, this article stems from an interview between my fellow XRP YouTuber Crypto Eddie and a lawyer named Jesse Hines, who has been rather vocal within the XRP community lately, really ever since what's happened with the SEC versus Ripple. And I appreciate all lawyers that are willing to share publicly their perspective on this, because with someone like me not having a legal background, without people willing to speak out on this, I'd be lost. I guess there's no way I could read legal documents that offer clarity, and without having an understanding of what the full implications are from a legal perspective, it wouldn't even matter. So I always appreciate this stuff, and there's some genuine insight, which I think you're going to find fascinating here. And I did watch the whole discussion between Crypto Eddie and Jesse Hines. It was about an hour long. Interesting stuff. But this is a pretty good summary of some of the high points here, and so I want to kind of run through this here. Now, I do want to be clear that I don't have a financial background of any kind. I am not offering financial advice. And you definitely should not buy or sell anything because of anything that I say or write. I'm just an enthusiast. I like talking about these things, XRP and crypto-related topics, and I make YouTube videos as a hobby, but that is all that it is. So let's jump in now. Jesse Hines, an attorney at Hines Law Group, discussed in a new YouTube video from Crypto Eddie his take on Ripple Labs' Freedom of Information Act, that's FOIA for short, F-O-I-A, letter that the company filed as part of its response to the SEC complaint. From the perspective of many, Ripple has made a bold move by requesting information through the FOIA request about how the U.S. Securities and Exchange Commission determined Ether status as a non-security. Yeah, and I've talked about this on the channel, and that's important because you know what Ripple's going to do with this, right? A couple of things that'll be fleshed out in this, in this video here. Thanks to clarity from Jesse Hines, but it's pretty clear to see that Ripple absolutely intends to compare XRP to Ether, and whatever information they get, assuming they get it through the FOIA request, they're going to say, okay, this looks I don't know. Like, your logic is applied in for one cryptocurrency and then not applied to another. That's effectively what they're going to get at here, because there are going to be so many similarities you could draw between Ether and XRP in terms of what it should be classified as. And it's interesting in that you're going to be putting the SEC on defense. And I don't think that they're going to have, like, they'll try and make an argument, sure, but I don't think they're going to have a logical leg to stand on, frankly. Anyway, piece continues. The Freedom of Information Act specifically asks for all communications with the Ethereum Foundation and or other relevant entities, including but not limited to Consensus, or individuals in the Ether ecosystem, including but not limited to Vitalik Buterin, Anthony DeLorio, Charles Hoskinson, Mihai Elisi, whose name I'm sure I said wrong, Amir Chetrit, Joseph Lubin, Gavin Wood, and Jeffrey Wilkie, maybe I said that one right, or any attorneys or other individuals, and all documents upon which the SEC relied in deciding that Ether is not a security. So that could be a ton of information to put together, right? Which actually Jesse kind of gets to, so check this out. As Hines confirmed, the SEC has 20 days to respond to the FOIA request, so a response should appear around February 14th or 15th. In the attorney's experience, Ripple has a good chance of receiving a response since the SEC has not yet released a response. And here's a quote. In my experience with it, if Ripple is going to be denied, they probably would have already been told the grounds of denials. They usually get back pretty quickly on that. And then the piece continues. The SEC also has the ability to extend the deadline for an additional 30 days, although this is usually done when they need to release the information. Hines, with regard to the SEC versus Ripple litigation, filed a FOIA request himself to get all the information, but was denied within 3 days. In terms of why Ripple Labs lawyers decided to make the FOIA request, Hines made two assumptions. And this is where it's valuable to get insight from a lawyer, because without having the experience, you're not going to think of this stuff on your own. But check this out. Here's a quote. First part is that I do think we are going the public route for a reason. because they would be able to ask for this information in a private sealed discovery way where they couldn't share it. And so, to be clear, what he's talking about right there is they want to be able to state some of this stuff publicly. And if it's something that's sealed, because as he cited here, private sealed discovery way, then they wouldn't really necessarily be able to publicly talk about it. But it seems to me that based on what Ripple's actions have been and what Jesse's saying here, that they want to publicly talk about this because they know how absurd this is even prior to getting this information. Because whatever the rationale is, they're going to come back and say, but look at the similarities between XRP and Ether. How could you ever think that they should be classified differently? That's what they're going to do, I think. Anyway, his quote continues here, though. But second, I really think if this is going to trial, they are seeking information so that they can really compare, side by side XRP to Ether. They can say, look, how come that this crypto is good and this crypto is bad? I don't get it. That's the biggest reason they want this information. Exactly. And to me, that seems like it would be a powerful argument, does it not? Then they have the subheading, will the SEC do an about face under Gary Gensler? Hines also speculated on whether the U.S. Securities and Exchange Commission might make an about face in its stance on cryptocurrencies under its new chairman, Gary Gensler. As is well known, Gensler is well acquainted with the space. Most recently, Gensler was employed at MIT as a professor of blockchain, digital currencies, financial technology, and public policy in the business school and senior advisor to the MIT Media Lab's influential digital currency initiative. But that's not the only reason Hines thinks it's possible Gensler won't follow Jay Clayton's policies. And this gets interesting, so check out this quote now. What I think, and this is total speculation, what Gary Gensler might try to do is he might try to take a step back from prior actions. I heard Commissioner Pierce in a few talks, and she kept saying, this is a fresh start. So what we're talking about is since Jay Clayton has left, that asshat Jay Clayton, because mind you, on his last full day, decided to just crap all over everybody's holiday spirit by filing the SEC claims against Ripple on December 22nd. Last full day in his position. It's just completely absurd. But obviously, with the incoming Biden administration, there are always going to be shakeups. And what he's talking about here is Commissioner Hester Pierce, who is famous in the world of crypto, I think it's safe to say. She does seem to keep saying this is a fresh start. So while she's not specifically talking about the SEC versus Ripple, clearly there are going to be some changes here. And I've made the point before that clearly things were so bad with Jay Clayton and everybody that was in place at that time that there was no chance for settlement. Ripple tried to settle and they failed. There's no way it was going to happen, and so it's not going to get worse than whatever the hell that was. I can't imagine. Doesn't mean it's going to get better, but it could. As Hester Pierce here stated, it's a fresh start. And here's a quote from Jesse Hines, the attorney now. I think Gary Gensler will try for that fresh start. It could look like something as settling with Ripple to the point where they say, pay us for the past actions. We're not going to decide whether it is a security. And I still wonder if that's going to happen, though, because it seems to me that Ripple is insisting that be the case. And so attorney Jeremy Hogan, different attorney, has stated that since Ripple, in their answer against the SEC claims, this is a legal filing, mind you, I think the term was affirmative defense. Now, again, I don't have a law background, but I believe that was the term used in the document. And under that, Ripple effectively stated that they are demanding, pick your word, that XRP end up receiving regulatory clarity. So if this goes to trial, according to Jeremy Hogan anyway, we would get that. Now, if there's just some sort of settlement here, yeah, you could have this situation where they can't come after Ripple, which would make it safe to, for XRP to be held traded by exchanges again, and Ripple could move forward then potentially. But you wouldn't necessarily have that blatant write-up of, yeah, it's true that XRP is not a security. So there's no way to know for sure, but if this actually goes to trial, you're going to have a firm outcome one way or the other. Now, Peace continues. Nonetheless, Hines doesn't think a win for Ripple is guaranteed. As Ripple also noted in its response to the SEC, the central issue in the lawsuit will be the definition of an investment contract, and that term, Hines said, has never really been defined by Congress. And here's a quote. I think they have three really good arguments, but I am not saying that they are winning on any of them. To be quite honest, Ripple could lose this lawsuit. They really could. And it's not because I believe XRP is an investment contract. It's because an investment contract is broad. It could really mean a lot of different things. It was never actually defined by Congress. And so he said that. It's I don't know if he's just saying it to hedge his bets. I mean, I'm sure he believes what he's saying. To be clear, I'm not doubting that. But he seems to still think along the lines of your typical XRP holder, which is clearly that today XRP is not a security, and so it doesn't make sense for it to be declared as an investment contract because there is no contract. Did you sign a contract with Ripple? Your XRP could have been held by 100 different people before it even got to you, people and businesses, and somehow there's an investment contract. Like it's wacky stuff. It just doesn't follow logically. So I don't know. We'll just have to sit tight and see. But it'll be really interesting if Ripple is granted this FOIA request. Granted the information that they're requesting. That's going to be something, because that's something I believe they will publicly talk about, and that's going to be something. And I would love to cover it too, because that when Ripple makes the comparison, they're just going to tear the concept to shreds. They're going to place that argument into their wood chipper, and it's going to be a glorious day. It'll be a lot of fun. But I will go ahead and wrap up there. I am not a financial advisor. Do not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.